cartoons that we see as kids always show the bad guys being caught by the police and thrown immediately behind bars. But in the real world, this is not how things work. For this assignment, I was able to speak with a former deputy chief of police who was able to give me some great insight and depth into the criminal investigation and criminal trial. So there are two types of criminal offenses: a summary conviction offense or an indictable offense. A summary conviction offense is a less serious crime, and typically the police can release the accused on the spot for this kind of offense, on the promise that they will appear in court. They often have to sign a document to say they're going to do that. However, indictable offenses are far more serious. So the accused will be taken to the police station in this scenario, and either the accused will A, be released by a supervising officer on the terms of either one of the following types of bail releases, quote, promise to appear, PTA, an officer in charge undertaking, or a recognizance, unquote. Or B, the supervising officer might still doubt the accused will appear at his or her court date. In this case, the supervising officer will then proceed to a bail hearing, which shall be held within 24 hours. The police, and subsequently a judge, will use an acronym called RICE and the 4 Ps to determine if the accused will be released. When the police are considering whether or not to release the accused or proceed to a bail hearing, they follow an acronym called RICE and the 4 Ps, and it goes as the following. R. Repetition. Is there a chance that the accused will repeat the offense or another offense? I. Identity. Are the police satisfied with the identity of the accused so that they know it's secure and that the person can't run off in such a way that police cannot identify who the accused is? C. Court. Will the accused attend his or her court hearing and criminal trial? E. Evidence. Is there enough evidence that the police and Crown can take the case to court even? P. Protection of the public. Next P. Protection of the accused. Third P. Protect property. And fourth P. Prevent a further breach of the peace by the accused. At the bail hearing, it is determined by the judge whether or not the accused should go out into the public again on certain terms and conditions and various different types of bails, which is release, or if the accused should remain in custody. Most times the accused is released. However, there are certain scenarios, as I stated above, which they must consider before the judge will release an individual. When a bail hearing is held, there is always a defense and a Crown, and the two shall duke out whether or not the accused should be held in custody or not. It is by their arguments that the judge will make his or her final decision. After the preliminary hearing, not every case will make it all the way to the criminal trial. This doesn't happen if someone were to plead guilty, and one of the most controversial forms of pleading guilty would have to be plea bargaining. Plea bargaining is when the Crown gives an offer to the accused. This offer being a lesser sentence or fine, or charge even, if the accused says, "I am guilty." In R versus Homolka, Carla Homolka, along with her husband, Paul Bernardo, was charged in the deaths and rapes of 3 Ontario teenage girls. Carla Homolka was offered 2 charges of manslaughter and a tinier charge for one of the other murders if she pleaded guilty. However, after Carla Homolka pleaded guilty to these charges, it was discovered that Carla Homolka had a much bigger hand in the cases than anyone realized, seeing that there are videotapes and other evidence proving that Carla Homolka had intent and deliberately was involved in the deaths and rapes of these 3 teenage girls. Previously, Carla Homolka claimed that she was only an aid to her husband in the murders, thus the manslaughter sentences. However, these videos revealed that she truly was guilty of first-degree murder. It's important for us to understand what exactly is a jury and who can be selected for a jury. Can anyone be selected for a jury? In principle and concept, anyone can be selected for a jury. However, there are limits, even though juries are randomly selected. It starts off with once every 4 years when a municipal election goes round. Yeah, when you have to go and you vote for your city's or town's mayor. During this time, of course, you send out the ballot. Before you do that, you have to register for the enumeration voters list to say that you are voting. And when you do this, you have to give them some important information, such as your age. They want to make sure you're legally allowed to vote. You must be over 18 years age or 19 years age in some provinces. And you also have to put down whether or not you are a Canadian citizen. So, after the enumeration voters list is grabbed, this is passed off to each provincial jury centre. The provincial jury centre would then use a computer-based system which will randomly select people, and after these people are randomly selected, these people shall be mailed questionnaires which will ask them questions which will determine whether or not they can be jurors. While there are qualifications for being a juror, there are also dequalifications. Some of these dequalifications would have to be those working in anywhere linked to the legal profession. So, for example, lawyers, those working in the public sector, so vital jobs in the public sector, especially such as being a nurse or doctor, those with past track record of criminal offenses are not allowed to be jurors. So then the nitty-gritty happens. The questionnaires are taken a look at once they're mailed back to the provincial government, and then within the next year, jurors are selected by a computer system as to who goes to what court date based on where they live. This is randomly done, although all the people through the CPIC system, or the Canadian Police Information Centre, are taking a look at their criminal records, a check, and the sheriff takes a glance at whether or not they have a criminal offense. After this, a summons is sent out with the judge stating the date, the time, the place of their trial. The jurors shall go to their date as specified by their summons, and they shall either be accepted into the court trial or dismissed. As the lawyers, the defense and the crown lawyers, can choose to dismiss some jurors. When a juror is dismissed for bias, this is what we call a challenge for cause. Meanwhile, in a peremptory challenge, this is when the juror is dismissed without a reason. Then there will not be 1, not 11, but 12 jurors that shall be there at the jury and determine with the judge whether or not the accused is innocent or guilty. While CSI or FBI shows might dramatize and overemphasize the importance of DNA evidence, it's not the only form of evidence or the most important form of evidence. According to the former deputy chief of police I spoke with, he said that eyewitness accounts and physical property type of evidence that without the crime scene is the best form of evidence to bring to a court case. Eyewitnesses, when they get to the case, essentially orally will say to the court what they saw at the case. After this happens, the eyewitness is always subjected to what is called cross-examination, which is essentially the opposite lawyer asking that same witness another series of questions that might shed other light on the case. The problem with eyewitness accounts is that there's a concern that the eyewitness might fabricate the truth. Two common forms of fabrication that are illegal under the Criminal Code of Canada are perjury and hearsay. Perjury is simply when someone downright lies in court. So let's say Sonny Boy has been accused of murdering his father, and Mrs. Jones has been called as a witness. Mrs. Jones says, "Well, I think that Sonny Boy killed his father tonight because I saw the stabs. I saw him going up and down over his father's belly." The problem with this is that Mrs. Jones never did see this. Mrs. Jones only heard screams in the night in her house next door while she was lying in bed, and assumed it was Sonny Boy's father. The other form is hearsay, and the way hearsay works is it's unproven evidence that should not be admissible to court. So kind of like gossip. So let's say Mrs. Jones, instead of lying, said that, "Well, I heard these screams in the night, and they were so blood-curdling, and they sounded like they came from next door. I'm positive that those screams, and it must have been Sonny Boy's father." The problem here is that her claim has not been proven. There's no way actually to prove that it was Sonny Boy's father. She can connect the dots, but it's circumstantial evidence, and thus her hearsay here is inadmissible to the court. Another type of witness used is expert witness. An expert witness is, as the name suggests, an expert in the area who can give his or her opinion or expertise to a certain part of evidence in the criminal trial. So, for example, when talking about DNA evidence, you might get a forensics expert who would be able to tell more about the DNA and how accurate it is, etc. Another type of evidence used, as mentioned earlier, is physical evidence. Physical evidence is usually either biological in nature or is something such as a weapon used at the scene. The presumption of innocence is one of the most important concepts in Canadian court system. The presumption of innocence is that the burden of proof or the onus is on the Crown, the prosecutor, and not the defense. The burden of proof, to explain it simply, is that one of the sides, either the Crown or the defense, must prove X beyond a reasonable doubt. So in this case, in the Canadian court system, it is that the Crown must prove the accused is guilty beyond a reasonable doubt. If the accused cannot be proven guilty by the Crown, even if there's any doubt, then the accused must be acquitted or have his or her charges dropped. The way this works in the ending is after the defense and the Crown give their evidence to the judge will make the final deliberations to decide whether or not the accused is guilty. Sometimes it's not just a judge, but also a judge and a jury, in which case the jury will vote and the judge or a few judges might vote, and their deliberations are weighed together into determining whether or not the accused is innocent or guilty. When someone is accused with an indictable offense, this person often has a choice to elect either judge only or judge and jury, and what level of court he or she wants, so either provincial court or federal court. However, there are some indictable offenses where the accused has no say, such as in a murder charge. It must be at a federal court, and it must be before a judge and a jury. Summary convictions offenses, however, you cannot make a choice as to what court you are seen before. It will always be provincial and always be judge only. So what can be concluded about criminal trials in Canada, and generally speaking, the judicial system in Canada? It can be concluded that criminal trials are complex, long proceedings with many rules and details. Criminal trials are not as simple as a crime TV show might suggest. For example, in The Mentalist, in one of the seasons, Patrick Jane, the main character, is accused of murder. The murder trial only takes a few hours, and beforehand, he's allowed to be on bail. This is very unrealistic. In reality, firstly, murder trials can take months to solve. It's not like within a few hours all the evidence can be brought before the court and the judge or jury can say, oh, he's innocent or oh, he's guilty. And further, when someone is convicted of murder, they're typically not allowed on bail. So the next time you're watching a crime show, pause your show if you think it's unrealistic and maybe go do a bit of digging, maybe on the internet, to see if what they're presenting is accurate and true. While crime TV shows can be fun, it's important to keep in mind that we're only watching fiction, and that criminal trial in real life is a challenging process. We need to respect the amount of time and energy our judicial system puts into criminal trials in order to protect the public and the accused from injustice.